What's up, guys? This is a very important video because we're going to be covering LLC mistakes that could cost you everything in the event of a lawsuit. Okay, let's get started. Okay, so here's the thing. We talk about using limited liability companies to protect our assets and how beneficial they are. But what happens when a lawsuit develops against you personally, not against the LLC? I'm not talking about this right here, right? Where you have a limited liability company set up and you've got your property inside of that LLC and you're down here owning it and the lawsuit begins up here. We know that, right? If a lawsuit happens at the LLC level, then it's going to stay inside of this box and you're going to be protected. That makes me happy. That's why I set up this limited liability company. You see, the other side of using LLCs is that we want to protect our assets. Okay, get this. We want to protect our assets from our liabilities. So I want to make sure that if I have a property in there and I'm down here and I'm involved in a lawsuit, all right, so this person has sued me and they get a judgment against me for $275,000, that they can't take that judgment and attach it to that property because it's held in a limited liability company. Now, I've talked about the protections with limited liability companies. If you look up videos, if you just search my channel for charging order protections, you'll know what I'm referring to. It states that if you sue somebody, if you have the right LLC set up in the right state, that the creditors are only entitled to a charging order, which means they can't take your LLC from you. They can't force you to distribute assets out of that limited liability company. They can't get into the company and cause problems for you. They just got to sit there until you take money out. That's the general rule. Be amazed how many people screw this up, okay? And the reason I wanted to cut this video because there's a recent case out of Utah and one out of Alabama just this year that dealt with this issue, where an individual that had assets in LLC was sued, a judgment's rendered against them, and their LLC crumbled around their ears and they lost their assets. I don't want you to make that mistake. So I'm going to tell you about what happened here and how it easily could have been prevented. So here's the scenario. This guy, he has a bakery in Utah, and he sold his bakery to one of the big companies out there that bake breads, like Pillsbury or something like that. He sold his bakery, and when he sold his bakery for, I don't know, say 10 mil, they said they required that he sign a non-competition agreement that he'll not go set up another bakery, and I don't know how many years it was for, but he couldn't go back into the bread baking business. Okay, no problem. So he then went and he set up a limited liability company in Nevada. So he sets up this Nevada LLC he set up, and then he foreign filed it in Utah. Now he listed himself as a member at 48%. He listed his wife as a member at 48%. And then he had his kids, 4 children, also listed at members with a 1% interest each. Okay, so that's how he created his LLC. So now, and then once that was set up, he put the 10 million into here. He also had a property that he put into here as well. So he put all these assets in there. So his first mistake is, of course, putting real estate with cash, right? Because that's a dangerous asset. You don't want to do that. But he did. All right, so everything's fine. He's got this LLC set up and he and his wife are running it. But then he decides, I'm going to go back into baking bread. And so he opened up a bakery, set up a new company, opened up a bakery. And of course, the company that had bought him out said, wait a minute, you're in violation of our agreement. You can't do this. He's like, screw you. I can do whatever I want. Well, that's a wrong attitude to take because they had a ton of money. They hired a team of attorneys. They came after they sued him. And they get this $4 million personal judgment against this guy, right, for what he did. Now, they then went and obtained a charging order on his LLC. They got a charging order on his limited liability company. And so the court told them, they said, sir, if you take out a distribution out of this company to yourself, let's say you decide to pull out $500,000, then you need to pay that over here to your creditor, which happened to be this company. You got to pay them this until you've paid them the $4 million you owe them. Pretty simple, right? Do you understand what I'm telling you? Yeah, I understand. If I take out any money as a distribution, I got to pay it to my creditors. Great. So what does he do? He doesn't take out any distributions. Takes no distributions out of his company. Doesn't distribute himself anything. In fact, he turns around a couple years later and he sues the company over here to get the charging order removed from him. And his point in the case is this: hey, I don't even own this LLC. You got a charging order against an LLC that I'm not even a member of. What an idiot you guys are. And so they defend, they go, what are you talking about? You don't own the LLC. He said, well, before this lawsuit, before you got your charging order, I transferred my 48% interest to my wife. I don't even own it. You guys are fools to put a charging order against me. I don't have an interest there, so you can't do anything. And they said, okay, well, let's take a look at that. So they looked at his assignment of interest. So he had this assignment clause or agreement that he put together where he said, I hereby assign all my interest in this LLC to my wife. What did the court do? They looked at that and they said, that assignment was not effective. Why wasn't it effective? So this is where he screwed up. He put this LLC operating agreement, I presume, together on his own, or he didn't even understand what was in it. Because when he prepared this assignment, he did not do it per the terms of the operating agreement. So the operating agreement specified that in order to assign an interest, a membership interest, you have to go through 6 different steps for it to be an effectuated transfer. He didn't go through those steps. And so when the court came after him, they said, or when the plaintiff came after him, they said, wait a minute, you didn't do it the right way, therefore it's null and void. And the court agreed. So here's what I'm trying to tell you. First off, you need to know what your operating agreement says before you transfer interest. Otherwise, later on down the road, you may find that transferred interest is not effective. And that could put you in this guy's situation. But that's not even the worst of it. So now they've said, no, you're still a member in this LLC at 48%, of which there's a charging order against your interest. So now they went out and they said, hey, we've never been paid. So then they started looking at the LLC and the money that was coming out of it. And what they saw was that the company was distributing assets to the wife, making distributions. So this year she received $250,000. This kid got $15,000. This one received $25,000. Maybe this one only got $2K and this one got $0 because they didn't need any money, presumably. So they're pulling money out of the LLC to them. He's never taking a distribution out of his company because he was told that if he did, he had to pay it to the creditor. Now, they also have this house up here, and they're living in the house, right? And they're paying the expenses of the house, the power bill and the water bill out of the limited liability company. And the guy's sitting back going, hey, I'm not taking any money. So then the creditor company over here again, they came back in the court and they said, wait a minute. You have deemed distributions. So for the past 6 years, your wife has pulled out of this company $2 million. And you're saying you haven't pulled out anything. He goes, no, I didn't pull out a single thing. Well, we're going to impute $2 million to you. How were they able to do that? Well, when he set up this LLC, and if you look back at one of my videos, the 8 essential provisions you need in every limited liability company, if you look at provision number 3, I'll put the link in my show notes for you. I cut this video, I think, a year or 2 ago. It has a ton of views on it. So my third point is this, you'll see in there. The third thing you should have in every limited liability company operating agreement is the ability to enter into non-pro rata distributions. What does non-pro rata mean? It means this, that if I had $1 million to distribute, I could make these types of distributions right here. I could give it to, $800,000 to my spouse and split the other $200,000 amongst the kids, and I don't have to take anything. That's why you want that provision in there. He didn't have non-pro rata distribution provision in here. Just like I stated in my video, he had a pro rata distribution clause in his LLC. And under the pro rata distribution clause, it states that if you want to distribute out $1 million, you have to distribute it equally to every partner based on their membership interest. So the court looked at that and said, hey, you violated your operating agreement, or actually what it will tell is you received $2 million, you didn't pay it to your creditor, so now we're going to appoint a receiver. And that receiver is going to step in, control all of this, and essentially what they end up doing is liquidating the assets and paying them over to the creditor, just like that. This is how LLCs fail to protect people, because individuals set up operating agreements and they don't understand the provisions in there and the importance of when you're drafting an operating agreement that you're covering your bases. You don't want pro rata in there. You want non-pro rata distribution. So if you did get sued and there's a charging order, you can give the assets to your spouse. Another case out of Alabama, the exact same thing happened. The LLC failed. The creditor was able to get after the assets. Why? Because the individual did the exact same thing here. He took distributions, gave distributions to the spouse. He took no distributions. Creditor came back in and said, wait a minute, you should have been taking distributions because your operating agreement provided for pro rata distributions. I see that all the time in LLCs. People download them off the internet, they sign them, and they don't realize the traps that are waiting in there. So if they do find themselves in a lawsuit, those traps are going to get sprung and they're going to get hammered. They're not going to receive the protections they're looking for. Not to mention you do stupid things like use your credit card in the LLC to cover personal expenses. Now, if you're wondering, well, Clint, what happens? How could you receive money out of your LLC in this scenario? Well, number one, here's what I'm going to do. When we create our LLC operating agreements, they have non-pro rata distribution, so you can distribute the money out. But the other thing you want to do is this. Charging orders only apply to distributions. You could pay yourself a management fee for running that business. That's what he should have been doing. Pay himself a management fee, not subject to charging orders. He could have taken a loan out of the company as well, not subject to charging orders because it's not a distribution. In fact, in the Alabama case, the court even stated that. They said there was other ways he could receive money from this LLC that we would have recognized as legitimate payments to him that weren't subject to creditor attachment, but he didn't do that. Don't make these mistakes with your LLC. Understand the provisions that are in there, so if you find yourself in this situation, you're not going to have somebody coming through and tearing apart your structure and getting after your assets. Guys, this was a basic 101 level on how to protect your limited liability company, and I hope you understand what we're going for. If you've got any questions, throw them down there, down below in the comments. And if you want to see that other video I talked about, I'll put the link there. You'll see it in the show notes for the common mistakes that people make in drafting limited liability company operating agreements. Take care.